Hello, I am Greg Tufel. I'm the president of the Pittsburgh chapter, newly became president after the wonderful occasion of Dave Porter becoming our newest Third Circuit federal judge. And I have the honor and privilege this morning of introducing retired Justice Castille, who had served on the Pennsylvania Supreme Court as Chief Justice. He was the 55th Chief Justice of the Pennsylvania Supreme Court. Was elected to the Supreme Court in 1994, and I believe he retired in 2014, is that right? And was retained for a 10-year term in 2003 and again in 2013, but then didn't serve it all out. I guess the mandatory retirement age of 70 there. He was a member of the U.S. Conference of Chief Justices and served on its board of directors, is an elected member of the American Law Institute, is an elected board member of the Pennsylvania Legal Aid Network, and was a commissioner on the President's Commission on Model State Drug Laws, as well as a member of the board of directors of the National Alliance for Model State Drug Laws. He also served on the Pennsylvania Advisory Committee for the United States Commission on Civil Rights. And prior to serving on the Supreme Court, Chief Justice Castille practiced law with Reed Smith. He was elected District Attorney of Philadelphia from 1986 to 1991 and served as Vice President and Legislative Chair of the National District Attorneys Association and was Legislative Chair of the Pennsylvania District Attorneys Association. He's been recognized by many professional, civic, and veterans organizations for his leadership and service. He was the recipient of the Philadelphia Bar Association William J. Brennan Distinguished Jurist Award, the Pennsylvania Legal Aid Network Excellence Award in both 2011 and 2013. He was the first recipient of an award named after him, the Chief Justice Ronald D. Castille Judges Award by the Pennsylvania Bar Association in 2014. He was the Pennsylvania Bar Association Judge of the Year Award recipient, the National District Attorneys Association's President's Award for Outstanding Service, the National DAV Outstanding Veteran of the Year, as well as the Pennsylvania DAV Outstanding Veteran of the Year. He was co-founder of the Philadelphia Vietnam Veterans Memorial, dedicated in 1987. Chief Justice Castille was a commissioned officer in the United States Marine Corps and was medically retired in 1968 after 2 years of service from injuries received in combat action in Vietnam. He was awarded the Bronze Star with Combat V, 2 Purple Heart medals, and the Combat Action Ribbon. He's a graduate of Auburn University with a BS in economics and earned his law degree from the law school in the University of Virginia. So very pleased to welcome and introduce Justice Castille. Thank you.
It's my pleasure to be here to speak to the Federalist Society in Philadelphia on this beautiful day, finally. It's always interesting when we look at the federal government and the sovereign state government and the interplay between those two agencies. And we also look at the interplay between the federal courts and the state courts. So I'm going to talk to you about some of the interplay that you have in the federal courts and the state courts as they work as sovereigns against each other or with each other. The Supreme Court of Pennsylvania, of course, is the highest court in Pennsylvania. We're the court of last resort. So I'm going to ask a few questions. This is a test. How many Supreme Courts or courts of last resorts are there in the continental United States? The 50 states. And can anyone guess? You're supposed to know your history, you know? Civics. There's actually 52 Supreme Court states in the continental, Supreme Courts in the continental United States. New York State has the Court of Appeals, which is their Supreme Court. Their county courts are called the Supreme Courts, which kind of is a misnomer as far as we justices are concerned. But there's more than just, the other 2 states have 2 Supreme Courts. That's Texas and Oklahoma. One does civil and one does criminal in each one of those states. So it's 52 in the continental United States. But there are other courts of final resort, Supreme Court Supreme Courts that are recognized in the United States, and you'd be surprised that they are Supreme Courts and they are part of the United States judiciary. They are in Puerto Rico, the Chief Justice of Puerto Rico. The Virgin Islands has a Supreme Court. Guam has a Supreme Court, the island of Guam in the Pacific. The American Samoa has a Supreme Court. And the last one is, I've never met that justice, I've met all the other ones, is the Supreme Court of the Northern Mariana Islands. Has anybody ever appeared before any of those courts out there? So I'm going to talk a little bit about the interplay between federal courts and state courts. And Josh, thank you for inviting me to talk here today. And it's nice to be here with the Philadelphia chapter and the statewide chapter, and Dilworth for being one of the sponsors. I looked on your website, and the website says that one of the founding principles of the Federalist Society is that the separation of government powers is central to our Constitution. As you all know, the federal Constitution recognizes the sovereignty of the states in various different areas. So I'm going to get into and talk to a little bit about the interplay between federal courts and the state courts. And a lot of you might be practitioners in the federal courts. A lot of you might be practitioners only in the state courts. A lot of you might be practitioners in each of those courts together. There are certain things that happen in the federal court and in the state courts when those courts have to review each other's law or procedure and decide cases that come up before the federal courts and the state courts. The federal courts generally have to apply state law, as we all know. So I'm going to talk about, just to give you a little bit about some of the different issues, the prediction of state court decisions by federal courts, a petition for a certified question of law from the federal courts to the state Supreme Courts, the greater constitutional rights that can be granted under the Pennsylvania Constitution versus the U.S. Constitution, and finally, a couple of short things: a Prison Reform Act and the sentencing matters. So, the first one I'd like to talk about is the prediction of state court decisions in the federal courts, and what that happens is the federal judges will get a case where they don't. Where the law in the state is not quite settled, and they will often predict what our courts are going to do. And here's an example. It just came out in 2018, September 2018. It was from the Third Circuit. It was called Lupu versus Lone City. And the case was a title insurance case involving a real estate insurer's duty to defend in a title dispute and claims against an insured borrower mortgagor. The Third Circuit reviewed the existing state law and determined that the exact question under Pennsylvania law had not been decided. And here's the quote: its courts, Pennsylvania's courts, we predict would apply the in for one, in for all rule known as the complete defense rule, whereby a single covered claim triggers an obligation for the insurer to defend the entire action to a case a case about the insured's duty to defend. And that case is pending right now in the Third Circuit. And then what they're doing is they're saying that our court will either adopt that or not adopt that. So there's no answer on that one yet, but as these things grind through the system, then we will probably answer it at some period of time. Another case where the federal courts had to predict how we, the Supreme Court, would address product liabilities law is Tincher versus Omega Flex. And many of you might have heard that if you practice the tort law products liability cases. In that case, the Third Circuit predicted that the state Supreme Court would adopt the third restatement of torts as state law in products liability cases. But in Tincher, we did not adopt what the Third Circuit predicted. Instead, we did not adopt the third restatement in its entirety, but we adopted what is known kind of colloquially as the third statement, as the restatement of torts 2.5. We sort of went towards 3, back from 2 itself. So they got that prediction a little bit wrong, but they were on the right direction. The next thing we have is a petition for a certified question of law to the state Supreme Court. Does anyone know what that is? That's why I'm here, to give you a little info. I'll give you an example. Here's a 2007 case. It's called Kendrick versus the District Attorney of Philadelphia. This case involved the Pennsylvania Corrupt Organizations Act, where the defendant sought habeas corpus in the Third Circuit after the district court denied his relief. The Third Circuit granted the parties a certificate of appealability, and then filed that with the Pennsylvania Supreme Court as a certified question of law. And the question was whether the court would overrule an earlier decision called BESCH, B-E-S-C-H, and that involved the definition of a criminal enterprise under the Corrupt Organization Statute, which is our RICO statute in Pennsylvania. And the question does RICO apply where the enterprise is a wholly legitimate enterprise? Can that be a corrupt organization? We answered that question and ruled that we would not overturn the BESCH decision. An example of what is going on right now is the Catholic Church. You might have read about it today, where the federal U.S. attorney is going after the Catholic Church for the priest and penitent problems that they had with the state grand jury. So that's now in federal court under their RICO statute, most likely. I haven't looked into it. But that would be, we would try that in Pennsylvania as a wholly legitimate organization that's subject to the Corrupt Organizations Act. Another example of that is the Whitco Corporation versus Herzog Brothers trucking case in Pennsylvania case in 2004. That case asked the question of whether a judgment creditor could bring an action against a garnishee bank to compel a payment, alleging that the bank possessed the debtor's funds and that the bank had the duty to hold the funds for the creditor in escrow. The Third Circuit certified 3 questions to the Pennsylvania Supreme Court, and we answered those questions in an opinion, a published opinion, and we determined that state public policy prohibits a garnishee bank with notice of a judgment order from engaging in transactions with the judgment debtor that it knows or should know will facilitate the judgment debtor and attempts to avoid the lawful garnishment of assets. What happens after these cases are answered by the Supreme Court? Once they are answered, then they go back to the federal circuit court, Third Circuit in this case, to complete the appellate process. And there's one thing that we do not do in the Pennsylvania Supreme Court. Because of our internal operating procedures, we will only accept a certified question from a federal circuit court or the U.S. Supreme Court. We won't take it from a district court or any of the other courts, bankruptcy courts, any of those questions. It has to come directly from one of the circuits. And we did get one from the Fourth Circuit, I believe, and we had one Supreme Court question sent down to us. So you should know those things, and you should, if you're in the federal court, you might run across that where the judge will want to send it to our court, and then you have to come to our court to defend it, even though you want to be in federal court. But you will generally end up back in the federal court. You could start one of these cases in the state court, move it to the federal court on the monetary amount, and then get kicked back to our court, and then go back to the Third Circuit. Another one of the things that you might not hear about or might not know about is that we have greater constitutional rights under the Pennsylvania Constitution versus the U.S. Constitution. And what that means is we can look in certain areas of law and we can review what the Supreme Court has done, basically in search and seizure. And we cannot go below the Supreme Court standards or the U.S. Supreme Court. I'm talking about the U.S. Supreme Court standards, like in search and seizure. But we can go above, we can grant greater rights to individuals in our court system under our Constitution than under the federal Constitution. And I'll give you an example. There's a case from a 2000 case from our courts that made it all the way up to the U.S. Supreme Court. It's called Papps A&M doing business as Candyland versus the City of Erie. In that particular case, the Pennsylvania Supreme Court addressed an ordinance passed by the City of Erie that was a restriction, a First Amendment restriction on expression, a limitation of the time, the place, et cetera, of the expression. That Papps case went all the way up to the U.S. Supreme Court, but at that time, the jurisprudence of the U.S. Supreme Court was fractured under this O'Brien level of scrutiny towards governmental restrictions of expression under that line of cases. The main issue for us was the standard of review of First Amendment restrictions on expression, which was an issue in which the high court opinion was fractured. There was not a majority opinion in Papps' case. It was sent back to us. So on remand, we looked at we looked at what happened in the federal court, and we as a court decided that we're going to answer the question ourselves, even though the federal court could not answer that question because of the fractured nature of their opinion. And we decided we would not wait for the federal resolution of the question because it was an imperative for Pennsylvania citizens that it was imperative for the Pennsylvania citizens that the issue be decided now, since it was a statewide issue involving the freedom of expression. We actually decided it, and we gave greater protection to the particular expression at issue under the state constitution than would have been under the federal constitution, a greater level of protection. And the particular expression in that case, First Amendment expression, wasn't speech, it was nude dancing. So we gave a greater level of protection for that type of expression than the same issue was not decided by a majority of the Supreme Court. So we decided it ourselves. I don't want to really get into the area of search and seizure law. That's a highly technical area, but because of the difference in the Pennsylvania Constitution and the U.S. Constitution, our courts have decided that in Pennsylvania you have greater protection under our Constitution than under the federal Constitution. So someone who is being searched and seized has less protection thanks to the interpretation of the U.S. Constitution than we have interpreted in the Pennsylvania Constitution. So there are different levels of interpretation because of the different ways that these constitutions are written. I want to talk about another area that's important for us at the local level, but you should know about it also, and that's the retroactivity of a Supreme Court decision as applied to the state courts. The matter that most illustrates this issue arises from the Supreme Court opinion in Miller versus Alabama, where that court ruled that a sentence of life imprisonment without parole for a juvenile convicted of murder was unconstitutional. That was decided under the federal Constitution. I said, 18-year-olds have a certain level of mentality that they are immature, and a sentence of life without parole for like a 16-year-old is unconstitutional, and those sentences all have to be reviewed. At that particular time that sentence, that Supreme Court came out, the Supreme Court case came out, we had over 500 prisoners who were sentenced to life without parole as juveniles in our state prisons. And now they have a new federal constitutional right for review of their sentences that they did not have before because their sentences were already, they were already served, all of their appeals were final. And usually those, you would not have retroactivity in that kind of a case. But the problem arose for us on a local level is whether the Miller opinion was retroactive. The Supreme Court did not say in that opinion whether it was retroactive, so they left it to the states themselves to decide if all of these kids, 500 of them, and some of them are 60 years old now or older, if they have a new right to have a new hearing because of the constitutionality of the Miller case. The state Supreme Court struggled with that issue because the U.S. Supreme Court didn't address retroactivity. Some states said yes, it was retroactive, meaning everybody could come back and have a new hearing in those states. Our Supreme Court ruled that the constitutional right was not retroactive. It would only apply to new sentences or those sentences that were still in the appellate process. So now you have certain states that apply it retroactively and certain states that don't. So of course it took another round of appeals to the U.S. Supreme Court to answer the question they could have answered in the first instance. In Commonwealth Cunningham, our court decided that the Miller case was retroactive after it went up to the Supreme Court. All the other states who decided it was not retroactive had to then say, yes, it is retroactive, and give every juvenile prisoner who had that kind of a sentence a new hearing on whether they could still get life without parole, depending on how bad their cases were. If they were juvenile murderers and they murdered 4 or 5 people, that was still possible. But they sent the cases back so that they could be reviewed to see if one of these kids was like maybe a lookout or was being guided, directed by an older kid, and maybe he shouldn't be doing life imprisonment under the conspiracy theory. So all 500 plus juveniles in the state of Pennsylvania, after a while, were able to file habeas petitions in our state courts to review their sentences. And in the concurring opinion written by me, I stressed that I said, in all but the clearest of cases, extensions and innovations by U.S. Supreme Court decisions should be addressed by that court because of the disruption that results from a misprediction by state courts of a new federal decision that greatly affects state jurisprudence. And you can imagine what the advocates thought in the state of Pennsylvania, where we said this is not retroactive, as opposed to New Jersey, where they said it was retroactive. So it took some time for that case law to settle down into the state court system. Some of the other information that you might not be aware of if you're practicing in, practicing in these 2 jurisdictions is the Federal Prison Reform Act. And that was sponsored by Senator Arlen Specter from Pennsylvania. And that requires any state prisoner, before they can file a habeas corpus to the federal courts, they must first exhaust all state remedies before filing the habeas petitions in the federal courts. So they can't skip going through, if you have after you've been through your conviction in the state courts, you get your sentence, you cannot skip review in the state court under the Post-Conviction Hearing Act and go directly to the federal court. prisoners have to exhaust all of their state rights first. And that is a recognition of the sovereignty of the state and the sovereignty of the federal government. And finally, the one thing you should not know if you're you should know if you're practicing criminal law in this particular state is if you have a criminal matter in Pennsylvania courts or in federal courts, those sentences in the state courts cannot be served concurrently with a federal sentence. So a federal sentence cannot run concurrent with a state court sentence. So a lot of times there'll be plea bargains where they say, well, he's doing 10 to 20 in the state, so we'll give him 5 to 10 in the federal system to run concurrently with the states. Or he'll get 10 to 20 in the federal system, and they'll say, well, we'll give him 10 to 20 in the state system to run concurrent. And that can't happen by statute. So these are just some of the examples of the interplay in the different court systems because of the sovereign nature of government. And I know the Federalist Society sort of like wants to look at the sovereign nature of the courts and the legislature and the Senate and the executive branch, but there are two sovereigns that we're looking at here, and these are some of the ways that we have to interact with each other to try and make the law somewhat reasonable or responsible, and let attorneys know exactly what they have to do when they're faced with one of these issues that I just spoke about. So I wish you good luck on your meeting here, and you got a great day in Philadelphia, and I hope you get to see some of the sights in Philadelphia. And thank you for inviting me, and Josh, thank you very much.